Okay. Namaskar, everyone. Welcome to the and welcome to this session of the NIC interview series. My name is Shreya Nepal. I'm the Executive Officer for Nepal International ADR Center, NIC. NIC is an accessible and credible alternative dispute resolution center based in Kathmandu, Nepal. We offer arbitration, mediation, negotiation, and other dispute resolution services to domestic, cross-border, and international parties. NIC was founded in 2013 and restructured as a nonprofit company in 2020. It was founded by a multidisciplinary group of judges, senior advocates, chartered accountants, management consultants, professors, academics, and arbitrators alike. It was established with the noble aim of providing international standard dispute resolution services to clients so as to develop Nepal as a leading arbitral hub in the region, subsequently improving its economic standards and global recognition. We are also the constituent members of the Asia Pacific Center for Arbitration and Mediation APCAM, through which we provide an international roster of arbitrators, mediators, and a uniform rule and fee schedule to be applied universally in all member countries. As part of our engagement in creating, enhancing, and applying knowledge and skills in dispute resolution, we have envisioned this NIS interview series where we invite arbitration experts from all over the world to come and talk to us about their arbitral journeys, their life lessons, advice they have for NIC and Nepal, and to let the global community of arbitrators learn about NIC and its work. At the inaugural session of the NIC interview series, we brought to you Ms. Louise Barrington from Hong Kong. And now, keeping up with the tradition of bringing revered international arbitrators to discuss arbitration with us, for the second session of the NIC interview series, we have joining us from Texas, United States, Ms. Anne Ryan Robertson. Ms. Robertson is a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators. Not only that, but she has been the global president of the CIARB UK. She holds a JD and an LLM in international economic law from the University of Houston Law Center. She is an international partner in Lock Lords LPP's Houston office and acts as counsel and arbitrator in a wide variety of complex business disputes across various industries. Ms. Anne has been named to Global Arbitration Review's Who's Who Legal Arbitration since 2015 and is a member of a number of arbitral institution panels, including the International Center for Dispute Resolution ICTR, HKIAC, AIAC, KCAB, and so on. Ms. Anne, welcome to the NIC interview series.
Thank you so very much. It is a great pleasure to be here with you today. I wish I could have been there with you physically, though. Unfortunately, we have to be thousands and thousands of miles apart.
Well, that's totally okay, ma'am. We're just so glad that this internet has enabled us to at least have this kind of a discussion, even amidst a pandemic. But hopefully we'll get to have physical discussions and interviews soon enough. Now, jumping to the actual interview session, ma'am, let's start with your position as the president of CIRB. You have been the president of a major arbitral institution of the world, an international partner of a law firm, and an iconic personality for arbitration enthusiasts. We are awestruck by your amazing work trajectory. You appear to have done a bachelor's in English literature. What pulled you from that to arbitration?
Well, I think we have to put this all in perspective. I had a father that was, I won't say he was old-fashioned, but fathers of his generation didn't really have plans for their daughters to necessarily go into business. They thought that the best track for a daughter was probably to be a school teacher. And so when I was growing up, it was always, well, you should be a school teacher. You should be a school teacher. Well, if I was going to be a school teacher, what I was going to study was English. And as you mentioned, I actually do have an undergraduate degree in English. And I actually did teach for about 3 years. But I knew early on that that was not what I wanted to be, that I actually wanted to be a lawyer, but I kind of kept that quiet. And in fact, I remember the very first time I ever expressed the fact that I wanted to be a lawyer. And it wasn't to my family. Everyone in the United States, the young girls, babysit for other families so that the parents can go out and have a nice dinner or go to the movies, and you sit and you watch the people's children and you get paid. And I actually had to be at someone's house one night, and the husband hadn't come home yet and they needed to leave. And the wife was very exasperated, and he was a lawyer. And she looks at me and says, "Don't ever marry a lawyer." And I was about 16 years old. And I said, "I don't intend to marry a lawyer. I intend to be one." So that's when I first espoused the fact that I hoped to be a lawyer, but I did do that English degree first.
That is so good to hear, ma'am. It sounds like uh, the kind of things that you'd put as a quotation, like I don't intend to marry a lawyer, but rather become one. That's very bold of you to say that at 16. Uh, that brings me to the question. You told me that your father, like all fathers of that generation, was pretty old-fashioned. So it must mean that the judges and the lawyers, fellow lawyers that you worked with of that generation must have also been pretty old-fashioned, to say. So what was your initial experience in the courtrooms and everything like?
Well, I'd like to back up a little bit because I think it's important for you to know what my experience actually was in law school as well. And when I started law school, there was 80 people in what was called my section. And out of the 80 people, 8 were women. In fact, they had a new building at the law school, and the building codes in the United States require that there be a certain number of bathrooms based on the mix of people, the gender mix that will be in the building. And after they opened the building, they had to switch the bathrooms because they hadn't planned on women coming to the law school. And they had to make certain that they met the code that was required. And yes, I was always, for the most part, for the first 10 years anyway, the only woman, maybe 2 women, in the courtroom. There were instances, I can remember once standing up and asking the judge if I could approach the bench, which is the protocol in the United States, and was told yes, and to be sure and come real close. There was another time that I was before a judge and I was doing my argument, and all of a sudden he says to me, "Are you an attorney?" So I was, one that was just one of a few instead of one of many. Now in the United States, obviously there's no issue in terms of how many women may be in the courtroom, and most law firms are rapidly moving into having more women. And in the law schools, the women in some law schools actually now outnumber the men. In terms of the men that I came across, there were some that were very old-fashioned, but others were not, and it wasn't necessarily based on age. One of the people that I worked for, who was my mentor, was actually, he would have been a little older than my father, but he was a true supporter of me and allowed me to develop into the lawyer I am today. So you can't really tie it on age. It's more just a mental process.
Well, that's good and somehow optimistic to hear, ma'am. Now, as I had told you, we have a group of arbitration learning lawyers here in Nepal that NIC has been trying to work with, and a lot of them who some of them I can see them right now. They've joined us here today, and most of them who are going to have hear the recording of this interview later. They are all keen to work in the glaringly male-dominated arbitration sector in Nepal. These lady lawyers, let's call them. So, despite facing the kind of unfavorable unfavorable situations and gender discrimination in the legal field, I would like you to tell them that what is it that made you not give up, and how would you advise these newcomers to persist and win like you did?
Well, I think one of the things that you have to remember, and I actually saw this cartoon the other day and it resonated with me, is that people look at me and they may think that I'm very successful, but that's just the tip of the iceberg. You know, on an iceberg, you only see a portion of it, and the larger portion is under the water. And that's true for any successful person. All you see is what is perceived to be the success. But underneath, there's a rejection, there's hard work, there's disappointments, and all of those things go in to being perceived as a success in a particular field. In my instance, and this is a very long story, so forgive me if I talk too long. I started my career as a trial attorney, and even that was not an easy journey, because when I graduated from law school, women were not doing trial work. And everyone I interviewed with was, well, why don't you do estates and trust work? Or why don't you do family law? None of which interested me, because I wanted to do commercial litigation. And I looked around and I found a job that I thought might give me some greater credibility. And I took it. And I spent a year there. And then I was very fortunate to have an opportunity to clerk for a judge. And after having clerked for the judge, which is one of those old men, by the way, he was older than my dad as well, that opened some doors for me. So the first many years of my career, I was actually a trial attorney doing commercial litigation. But along the way, I became interested in arbitration. And the way I became interested in arbitration was that I had actually been involved in an extremely large lawsuit, so large that the client had hired 3 different law firms to represent them. And in the course of that case, and there were 20 other defendants, all of whom were trying to say that my client was responsible for an explosion that had occurred at a plant. And we ultimately settled that case. It was extremely hard fought. But that in turn led to the fact that we had a dispute with one of our insurers. And the client and the insurance company entered into an agreement that they would arbitrate their dispute in London. And because I had been what we call in the United States the law lawyer, meaning I was the one who argued all the motions in court, I was the one who was most familiar with everything that had occurred in the case. And so I ended up not only being a witness in this international arbitration in London, but also assisting the barrister and the solicitor in the preparation of the case. And so I walk into this hearing room, and it was like I was back in law school again. I was the only woman in the room. And the arbitrators were 3 men. The barristers were all male. The assistants were all male. And I watched this unfold in a room where they were deciding a $100 million dispute with not a judge in sight. And I thought, this is very interesting that people would allow individuals like this to make decisions. And so I decided I wanted to do international arbitration, but I didn't know anything about international law. So the first step was to go back to school. And that's how I got my LLM. I went back to law school, got an LLM in international economic law.
Wow, that's so motivating, considering the fact that it is just my first week of joining LLM here in Nepal. So I'm also studying international business and trade law. So, okay. And now, ma'am, I cannot help but notice this. That's a beautiful shawl that you're wearing. Is that a pashmina?
It is. In fact, I'm wearing it in celebration of being interviewed here today. I have not been to your lovely country, but my son and husband have. And this is one of the souvenirs of many that they brought back to me from Nepal. So it's a real thrill for me to get to wear it today while speaking with you.
Thank you so much. It's a beautiful shawl, and it looks really great on you too. Now, that brings us to the question of Nepal, in fact. So, ma'am, as you must have heard from your husband and your son that Nepal is blessed with amazing natural and cultural heritages. We believe our geographical position between two rising world economies, India and China, and our history of being a neutral and peace loving nation can play a big role in establishing Nepal as a front runner in providing arbitration and mediation services to the rest of the world. So, how do you think Nepal can make the best use of its assets to develop itself as a leading dispute resolution hub?
Well, I think Nepal has taken the first of many steps that need to be taken, because I understand you are a signatory to the New York Convention. And that is the first step that any country that's interested in doing international arbitration must do. And that is because when people are looking for a seat for arbitration, they will only seat their arbitrations in New York Convention countries. And that's because, as you know, if you're a New York Convention country, there is a certain stability that is permitted in terms of the enforcement and recognition of arbitration awards. But that's just one small piece, because the next thing that you need to have is a body of arbitration law that is friendly to arbitration. And you need a judiciary that understands the importance of arbitration and will not be thwarting the process by intervening in arbitration, by causing difficulties, and by refusing to recognize awards. All of those things play into it. In addition to that, and that's on the legal side, which is, of course, very important, you need a physical infrastructure. You need to be able to have, now this is not quite as important as it was before the pandemic, but you need to have meeting spaces. You need to have copy machines. You need to have court reporters, whether it is by recording or stenographers that are taking it down, but those are all very important. And going with that, you need to have an opportunity, or shall we say a place, where the people who come to Nepal for the arbitration can stay. So it's a whole package that you must have. And overlaying all of this, and it goes back to what I was saying in the very beginning, you have to have the support of your government. Your government has to see that this is something that they want to do, and they need to realize that if in fact they support arbitration, that helps the underlying economy of the country as well, because it brings in foreign people who spend money in Nepal that might not be coming to Nepal otherwise. So it's a whole package of things that you have to have. And we can't forget also that you need to have lawyers that are trained as one to be arbitrators. And it's helpful to have a full roster of arbitrators from elsewhere and not just Nepal, because that gives comfort to those who want to seek their arbitration in Nepal, that in fact it views itself as an international arbitration center. And of course, you need to have knowledgeable lawyers, knowledgeable advocates about international arbitration, people who understand that arbitration is not simply litigation in another form, that it is its own distinct means of resolving a dispute.
All right, ma'am. That's quite a number of things that we have to ensure, and I have taken note of everything that you've said. Thank you so much for that. And yes, I do agree. I wholeheartedly agree on the judiciary having to keep their hands off of things. That's one thing that our judiciary and all judiciaries that want to accept arbitration have to ensure. Um, so yeah, so speaking of good national laws, I would just like to add for our audience how imperative it is to be as you've already mentioned, to be a member of the New York Convention in order for arbitration to flourish in a country, which Nepal is. Uh, likewise, there's now the Singapore Convention on Mediation, which again tries to make the mediation settlements binding for all the member countries. So it is a seemingly new concept, a new convention in terms of convention ages. And there are now talks of Nepal being a member of the Singapore Convention on Mediation. So what would be your thoughts, your expert thoughts on Nepal ratifying the Singapore Convention, if it ever does?
Well, last time I looked, there were only 8 countries that have ratified the Singapore Convention at this time. And that allows some people to believe, and I think wrongly, that in fact the Singapore Convention is not going to be important in the international trade arena. And I think that's wrong, because if you go back and you look at when the New York Convention first came into effect in 1958, you'll see that there weren't that many signatories in the beginning. In fact, the United States, which of course is a big user of international arbitration, did not ratify the New York Convention until 1970. The UK, it was 1975. So I think you cannot contend that simply because only 8 countries have ratified, that in fact it will not have any, we would say in the United States, legs, meaning strength. I will say this, that it's interesting to see which countries have in fact ratified at this point, and they are stretched across the globe. They don't look like they're necessarily trading partners with one another. And one of the things that the Singapore Convention has that apparently, as I understand it anyway, is that, for instance, those countries that signed the Singapore Convention are obligated to recognize mediated settlement agreements that conform with the Singapore Convention, even if that mediated settlement agreement is developed and signed in a country that is not a signatory to the to the Singapore Convention. So I think it's extremely important. I will tell you that it was my great pleasure last year to chair the committee that rewrote the rules or amended the rules for the International Center for Dispute Resolution, which of course is the international arm of the American Arbitration Association. And in those rules, in the mediation rules, the ICDR chose to make reference to the Singapore Convention, and it is the first set of rules that does so. And when we rolled out the rules, especially in Asia, and did presentations like this one, especially the Asian countries were very excited to find out that the Singapore Convention was being recognized in the rules, because mediation has always been such a part of the culture in Asia.
Indeed, indeed. Well, that's really great to hear, ma'am, considering how Nepal is on the process of it. Now, would also like to make a reference to your work. I saw that CIARB was an observer at the UNCITRAL working groups focusing on investor-state dispute settlement and expedited arbitration. So, what are the recent instances of the use and necessity of expedited arbitration?
Well, as you know, the Chartered Institute does not administer arbitrations. They do, however, make appointments. And they have a set of expedited rules, ad hoc rules, meaning that they are not administering it, that parties can use. And that makes the Chartered Institute unique, because there are expedited rules in almost every arbitration set of rules around the world. The manner in which they are done can differ. For instance, the ICDR rules, a certain amount in controversy will trigger the use of those rules. Other rules, as you well know, will simply provide that the parties can agree to expedited rules, and it won't necessarily depend on how much is in controversy. So the UN decided that they wanted to look at this issue of expedited arbitrations because it has become so prevalent in the administered arbitration world. what happens when you are an observer at the UNCITRAL is that you're allowed to make interventions. And what an intervention is to make statements regarding your organization's experience. So we were able to make an intervention at the UNCITRAL meeting to give them the Chartered Institute's experience in expedited procedures. And because they're ad hoc, it made us stand out from the arbitration institutions who were also giving their comments. And everyone, the Chartered Institute and also the institutions, are very much in favor of expedited arbitration because it gives the parties what they wanted in the first place, which was a speedy resolution of their dispute.
Thank you. Thank you so much, ma'am. That was very insightful. And now let me ask you a question that is going to be, I think, a recurring question in all our interviews, primarily because I want our audience of law students to engage in as many moot competitions as they can. Because I, as a law student, was say I was not smart enough, let's say, to know that how important it is to get into mooting back when you were in your undergrad days. So being a coach of the William C. Wiz International Arbitration Moot team, how important have you realized mooting is for aspiring arbitrators?
I think mooting is essential. And I think it's essential in two reasons or ways. One is I think that mooting gives you a better foundation in terms of what is expected in international arbitration. You know, I coached the University of Houston team for 18 years. And the first year that I took the students to Hong Kong, there were about 20 teams. The last year I took the students to Hong Kong, I've lost the number at this point, but it was way over 100. So in fact, the idea of mooting has caught on worldwide. And if you go on the internet, you will see that there are now any number of pre-moots as well, where students can practice. So whether you prevail at a moot or not, the fact that you're, one, getting this experience is extremely important. And two, you're going to get to meet people from all over the world. And that is also a great benefit of participating in moots. Now, in the past, of course, it required you to have to travel, which could be an impediment for students. I know I was very fortunate at the University of Houston that we would get some funding from the university. I also know that there were students that went to the Hong Kong moot who went out and raised their money by going and getting donors to give them money so that they could go. Now, because of the pandemic, the moots are being done online. So there is not that barrier that there was before. Now, I know everyone hopes that we can get back to in-person mooting because you do lose something if you're doing it online, but nevertheless, online arbitration is here to stay. People will be doing it. So that's a skill you need as well. But that's on the student side. Now, once you graduate, I would urge you to still be involved and to be involved as a coach. And the reason I would urge you to be involved as a coach is that you continue to learn. And going as a coach is a different experience because then you are meeting the arbitrators and the people that are actually working in the field. And that in turn gives you an opportunity to interact with practitioners so that you're developing your own expertise in the field of international arbitration while helping the younger generation or the younger students as well.
That's I think going to be a life-changing advice for me at least. Thank you so much, ma'am.
You're quite
Now,
welcome.
well, now let's just focus on the students for a little bit, and let's talk about Charter Institute's student membership and the mentorship program that I heard was around right now. So could you tell us a little bit about the CIRB's work and what it has for the students?
Sure, I'd be happy to. We need to go back 100 years ago. The Chartered Institute was started 100 years ago by 5 visionary, and I have to say it, men. There were 2 solicitors, there was an architect, there was an accountant, and a quantum surveyor. 5 men. And they wanted to raise the profile of arbitration, and they also wanted to make the role of being an arbitrator a learned profession. So 100 years ago that started. The Chartered Institute is now has a royal charter, which it got, and it has certain requirements. That charter is for them to educate people in the field of alternative dispute resolution, with the idea that disputes can be resolved without going to the court. Now, although the name says arbitrators, if you look on the website, you will see that among the training that is offered is not only in arbitration, but also mediation and adjudication. Now, as you alluded to, there are a number of different membership levels, and let's go through those, and then I will talk about the student level. First, you have what is called an associate, and this is someone who is interested in arbitration. And there is a course to take. It's a very short course to take to then become an associate member. And one of the things about the Chartered Institute, it's not an organization which you just get to spend money and belong. You have to show proficiency in alternative dispute resolution to be a member. The next level is called member, but that's with a big M, a large M, capital M. And this is someone who has demonstrated greater expertise in the field of arbitration, and again, or mediation or adjudication. And again, there are courses that will allow you to reach the member level. Then you have fellow. Now, a fellow is someone who has demonstrated total proficiency in the field and is viewed as someone who is competent to run an arbitration, conduct a mediation, and the like. Now, all 3 of those levels are allowed to use post-nominals, and I don't have it on the screen, but I would have FCIR after mine because I'm a fellow. When you introduced me, you mentioned another level, and that is the chartered arbitrator, and that is the top level. You have to be a fellow to be a chartered arbitrator, and to become a chartered arbitrator, you have to submit awards that you have written, sanitized so that no one knows who the parties are. And you have to undergo a peer review before you can be designated a chartered arbitrator. Now, the Chartered Institute has 17,000 members worldwide in 149 countries. And those members are divided into branches. And the East Asia branch is actually the largest branch in the Chartered Institute. Now, the East Asia branch then has many chapters, and these are more localized to allow the members to have an opportunity to interact with one another and the like. We do have another membership, and that is the student membership, and it differs. And the reason it differs is that you, first of all, don't have to take any courses to be a student member. You just have to have expressed an interest in arbitration, mediation, or adjudication. And this membership is free. So all you have to do is sign up, and you can do that on their website, which is ciarb.org. And then you will be receiving all of the publications that the Chartered Institute makes available. And you will see, if you go on the internet, that often there are programs that are being put on by the Chartered Institute that are free, that you can just sign up for as well. You asked me about the mentoring program, and that's new. It was started last year during my year of the presidency. Right now, it's limited to about 250 people because it's still a pilot program. The idea is to assist our associate members and our members with the capital M in becoming more familiar with arbitration, mediation, or adjudication. And so the people that are participating in that are assigned a mentor. The mentor is a member who's agreed to participate. And it's tailor-made to whatever the needs are of the person who is the mentee, the person who is being guided by the mentor. And it has been met with a great deal of praise. There's also other programs that are online that can be taken, again, to assist you in developing a career in alternative dispute resolution.
Thank you so much, man. That must be very helpful for our students who will be looking at, will be watching this interview. Now, I must say, as much as I love talking to you and how smooth this conversation has been going, I would like to say that we are almost at the end of the interview session. So if anybody has any questions, I would like to kindly write them on the chat box and then shoot them. And while the participants are writing their questions, I would like to ask you our final question, which is that since we're almost at the end, the nature of arbitration itself deems it confidential. All the cases that you do are confidential, and I love the terminology sanitized awards. That's something new for me. So you just remove the names of the people and the disputed amounts and everything, and you just give the facts of okay. So yet I know it's confidential, yet we're drawn to ask you, what is your most memorable working experience? Is there any particular case that has stuck with you all your life?
Well, I would have to say it was that very first one where I was a witness and also assisted the solicitor in the preparation of the case. And that's because it was my very first introduction to international arbitration. And I was just so fascinated by the process. And that in turn was the catalyst for me to go back to law school after so many years. And I must say that, I got the LLM in international arbitration, but at that time there in Houston, there were 3 or 4 firms that did international arbitration, but none of them were particularly interested in having someone who just got an LLM but had been practicing for many, many years to join them. And as a result, it's taken almost 20 years to ultimately get to where I wanted to be in the field of international arbitration, because I had to take a number of jobs that weren't exactly what I wanted, but did involve arbitration to finally get to an area and a firm where I was able to do international arbitration. But it has to be that very first case. Our barrister was Johnny Veeder, the late Johnny Veeder, who was so well known. I was very, very fortunate to see some of the absolute best in that one hearing.
That's great to hear, ma'am. Now I do not see any questions coming up from our guests. Yog sir, do you maybe have something that you would like to ask Miss Anne?
No, not really. I really appreciate what you said about encouraging arbitration in Nepal. We tried long ago. It's been 25 years. It was 25 years ago. We tried to do something when I was practicing in Nepal, but that was new thing that time. But now they have understood a little bit. Just to explain a bit about the situation of judiciary, although I'm quite away from that. The judiciary is quite supportive in Nepal, particularly in terms of arbitration, and enforcement has not really been a problem. The court has always enforced arbitral award. There hasn't been any problem at all. The legal framework, you probably wouldn't know, but what the system we have is more or less copied from outside. So our Arbitration Act is complete replica of the model law. So we have a pretty much stronger framework. There's still a need of a bit of understanding between different stakeholders. One of the problem what I have realized looking from quite away from Nepal and having understood a bit of context of Nepal is, the stakeholders such as the users are not as confident um, as to use the arbitration in Nepal. That's what one of the problem I have realized. It is from that time to now as well. The users are not that excited about using arbitration. And there's another problem what we have found. It's more of a business culture rather than anything else. It's like, if I think that I'm going to be losing the case in arbitration, uh, it would be beneficial for me to go to court and then put some sort of like application to stay in one or another way, and that happens, and then it just delays the whole process in one way or another. So I don't know if there's anything you could suggest for like Nepal to help with those type of problems.
Well, those are problems that I think are universal within countries, especially when they're first getting adapted to the idea of arbitration. And I think you raise a point that I had failed to raise, is that you're not going to be a successful arbitration center if the business people are not also educated on the importance of arbitration and what it can do for you. For instance, you make beautiful pashminas that are sent around the world. Let us say they were being sent and sold to someone in New York. Well, that person in New York is probably going to want arbitration so that any award would be enforceable. So you have to educate every sector of the legal community as well as the business community. For instance, the gentleman in Nepal that sold the pashimas and doesn't get paid, if he were to take that to court in Nepal, and let's say he got a nice judgment, it may or may not be recognized in another country. But if he had that arbitration award, it should be. So that's the entire education process for the business community. Then you have the education process for the judiciary. And fortunately, you say awards are getting enforced, which is wonderful to hear, because as you know, that can be a problem even within some of the New York Convention countries. They will not enforce, claiming it's a violation of public policy, or they'll find some excuse. And when people are drafting arbitration clauses, they look to see, what is the track record in that country? What is the judiciary doing? Are they hands off in the arbitration process, and are they enforcing the awards? Because that's key to being a good seat. And then in terms of your council itself, well, of course, that's something the Chartered Institute can help with in terms of training people so that they become competent in arbitration. Many of their courses right now are being offered online, which makes it more accessible to people than it might have been before. I always say that despite the fact that we can't be together and that we have to be on Zoom, that it is the silver lining to the black cloud, that in fact we are able to communicate across thousands of miles now, which we had not been able to do particularly well before. So it is indeed a process, but there are a number of regional arbitration centers that have been up and coming. You only need to look at Singapore. It was regional at one point in time, but it has the great backing of the government and has become extremely successful.
Yes, ma'am. I would just like to add one bit to the thing you said about everything falls under the violation of public policy. Well, this is a lesson that Nepal learned from India. That is a lesson that is something that we should not do, because it really pushed the arbitration development scene in India backward, because at one point, almost everything was listed under public policy in India, Indian courts, and it was impossible to get any arbitration award enforced. Well, now we have a question from Mr. Binod Prasad Sharma. Binod Shriman is also a director of NIAC, and he would like to pose this question. Dear Anne, we are facing the problem of frequent intervention from the court during arbitration process. What do you suggest in this regard?
That's educating the judiciary. You have got to educate them that once an arbitration is started, their role is very, very small. This is particularly true if you're working with an administered arbitration. The court should have absolutely no role in that. And in ad hoc as well, if they've chosen the UNCITRAL rules, the courts should not have a role. The court's role should be limited to the very beginning if someone seeks injunctive relief before the arbitration is started, not during, but before, and then at the end when there in fact is enforcement and recognition action. One of the problems that occurred in the United States, now our Arbitration Act came into effect in 1925. And one of the reasons it was enacted, and some of the provisions in there, are specifically to address the hostility that the courts had to arbitration. The courts were trying to find any way possible to avoid arbitration. And now our law is that if in fact there is a valid arbitration provision, it goes to arbitration. The courts don't get to intervene. And so the judiciary has to be educated on it for arbitration to in fact work in a particular jurisdiction.
Thank you.
Yes, and so thank you so much, ma'am. Now we only have a remark from Rajendra sir, who is also a director of NIAC. Since we do not have any more questions and it's almost time that we wrap up, ma'am, I think we should get to the end of the interview now. Thank you so much, ma'am. Now, so from the first arbitration case that you did, participated as a witness, to now you sure have a professional career we could learn from. Thank you so very much, ma'am, for your generous time. Your words of wisdom will motivate many of us here and instill a love and appreciation towards arbitration as a method of dispute resolution in Nepal, as the theme of this interview series goes, expanding arbitration opportunities in Nepal. So as much as this interview series is for the students and the arbitration enthusiasts, it is also directed at the businesses and all the corporate houses in Nepal that are still pretty reluctant towards arbitration as a method of dispute resolution. So with this, we have come to the end of the second session of the NIC interview series. I would like to offer my gratitude to Dr. Yog Upadhyaya, who all the way from UK has been helping us and has helped us bring this session come alive. And Ms. Louise Barrington and Ms. Alex Povey, all friends of NIAC, who have also helped me bring this session come to life. And to the entire NIC family and our wonderful audience for their support. And most importantly, most highly, Ms. N, thank you so very much for taking time out of your, I do not understand how busy you must be, your busiest schedules, to accommodate us and our institution and sharing your words of wisdom, your life experiences that are going to be very, very important for the growth of NIAC and for arbitration in Nepal.
Well, if I might add, if I may, it's been a great, great pleasure. I am pleased to have met everyone online. And if anyone has any questions for me later on, you can send me a message in LinkedIn and I'll be happy to answer them for you.
Yeah, and thank you very much for coming up, like getting up 7 o'clock in the morning, getting ready for an interview. That's absolutely, you know, we absolutely appreciate that. Thank you.
Yes, indeed. Thank you so much, Ms. Anne, and thank you everybody for your time and your patience. And this session of the interview series is going to be uploaded in NIC's official YouTube channel and shared in the social media. Please give out your comments and let us know how you liked our session. Thank you so very much. Thank you, everyone. Namaskar, and have a good morning and evening wherever you are.
Thank you.